All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning. Welcome you to the Kansas Supreme Court. This morning, we have one attorney disciplinary matter before us in case number 129013 in the matter of M. Stephen Wagle. Will counsel please state their appearances?
May it please the court, Alice Walker for the Office of the Disciplinary Administrator, present and ready for argument.
Jerry Bogle from Wichita, Kansas. My client, Stephen Wagle, is present, whom I represent.
Thank you, counsel. Ms. Walker?
Madam Chief Justice, may it please the court.
Yes, please.
Alice Walker, Deputy Disciplinary Administrator, on behalf of the Office of the Disciplinary Administrator, I respectfully request 3 minutes for rebuttal.
3 minutes is granted. Thank you.
Thank you. This is an original proceeding in attorney discipline involving the respondent, Stephen Wagle, who has been licensed to practice law in the state of Kansas since 1986. This matter comes before this court following a formal hearing before the Kansas Board of Discipline of Attorneys in January of 2025. Prior to that hearing, the parties entered into a stipulation of facts, as well as a stipulation to a single rule violation of KRPC 1.7a, conflicts of interest. Therefore, at the hearing in January, the parties only introduced aggravating and mitigating evidence. At the conclusion of the hearing, the Disciplinary Administrator's Office requested the respondent be disciplined by a published censure. The respondent requested to be informally admonished. In April of this year, the hearing panel issued its final hearing report in which it adopted the stipulation of facts by the parties, found that those facts, coupled with the evidence presented at the hearing, constituted a violation of 1.7 and recommended that the respondent be disciplined by published censure. Neither party took exception in this case. Therefore, pursuant to Rule 228G, the findings of facts and conclusions of law are deemed admitted. The conflict of interest in this case stemmed out of the respondent's representations of two individuals, B.A. and J.O. It started in February of 2020. B.A. was charged with a very serious felony case involving crimes against minors. He was ordered in that case to have no contact with the minor victims or their mother, and the respondent was appointed to represent him early in March of 2020. At the request of B.A., J.O. contacted Cricket Wireless, pretending to be the mother of the minor victims, and changed information on the account, thus allowing B.A. to violate the court's order and contact the mother of the minor victims. The court then ordered that B.A. have no contact with J.O., and an additional case was charged against B.A. for violation of protective order for contacting the mother of those minor victims. J.O. was listed as a witness in that case, and that all happened in March of 2020. The respondent was appointed to represent B.A. in that violation of protective order case. Then in May of 2020, two things happened. J.O. was charged with identity theft in relationship to her actions of contacting Cricket Wireless, and B.A. was charged with another case, violation of protective order, in which it was alleged he had contacted J.O. in violation of the court order. At that time, the respondent was appointed to represent B.A. He was not representing J.O. Then in June of 2020, the respondent withdrew from one of B.A.'s cases. That case was the violation of protective order case that had been charged in March, in which J.O. was just a witness. The respondent remained on the other two cases. In July of 2020, J.O. was then the respondent then entered his appearance for J.O. in that identity theft case. And in that case, she was also ordered to have no contact with B.A. The same day, July 7th, 2020, that the respondent entered his appearance for J.O., both B.A. and J.O. were charged with additional cases of violation of protective order, alleging that they had violated the court's order in having contact with one another. So as of July 7th, 2020, the respondent is representing B.A. in that major felony case, crimes against children, one violation of protective order case in which it's alleged he had contact with J.O., and J.O. in her identity theft case that stemmed from B.A. wanting her to contact Cricket Wireless. But at that same time, B.A. still has two other pending violation of protective order cases, one in which J.O. is a witness and one in which it's alleged he had contact with J.O. in violation of the court order. Those two cases, he had a different counsel. J.O. also had an additional violation of protective order case in which it was alleged she contacted B.A. in violation of the court order, where she had a different counsel. The respondent clearly recognized that this was a conflict of interest in this dual representation because he had his clients attempt to enter into waivers for this conflict of interest. And those waivers can be found at in the record, volume 3, Bate Stamp 12 and 13. It's ODA exhibits 3 and 4. He had BA enter into that waiver in June of 2020, and J.O. entering that waiver in July of 2020 before he took on her identity theft case. However, as the hearing panel properly found, the waivers were broad, non-specific, and did not serve to inform the clients of the specific risks involved with the dual representation. And that conclusion aligns with what's required under KRPC 1.7. The rules of professional conduct, specifically 1.7, indicate that if there is a conflict of interest that is waived, it must be informed consent confirmed in writing. 1.0 of the rules of professional conduct is our definition rule, and that defines under subsection F, informed consent, denoting the agreement by a person to propose course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. And the waivers simply did not have that information in there. They were broad, they were open-ended, attempted to waive all future conflicts, and did not even talk about those other cases that, even though the respondent wasn't representing them on those, still would create a potential conflict as they were essentially witnesses against each other. KRPC 1.7 comment 21 gives even further guidance that if the consent is general and open-ended, then the consent ordinarily will be ineffective because it is not reasonably likely that the client will have understood the material risks involved. That again points to these waivers indicating this broad attempted waiver by the respondent was insufficient to indicate to BA and JO what these risks were that involved in this dual representation with all of these cases pending. And even further, one of the conflicts that's not even addressed in these waivers is the potential that as witnesses, or you could call them victims against each other in these violation of protective order cases, they may have to testify against each other. And comment 6 to 1.7 says that a direct adverse conflict may arise when a lawyer is required to cross-examine a client who appears as a witness in a lawsuit involving another client. And that's the exact conflict that then potentially came to fruition at the end of July of 2020, when the prosecutor in this case sent the respondent and JO's other counsel a global plea offer to resolve both of her cases, but it would require that she then testify truthfully against BA in all of his pending cases. There were no additional waivers or discussions by the respondent about this actual real conflict that would exist at that time. And then finally, in November of 2020, the respondent on the record withdrew, citing the conflict of interest. Fortunately, JO had that other counsel who could be appointed in the felony case, and she was then afforded that same plea offer and was able to enter into it. The hearing panel found that these facts as stipulated to by the respondent constituted a violation of 1.7a. The hearing panel found that the respondent knowingly violated his duty to his clients, but caused only potential injury.
Can I ask you a question about the knowing finding that the panel made. Paragraph 58 says, the panel says respondent violated his duty knowingly. Respondent recognized a conflict of interest existed and attempted to obtain a waiver from each client. Thus, respondent knew he was violating his duty to provide conflict-free resolution. That can't be right, can it? I mean, because the rules contemplate obtaining these waivers, right? So wouldn't a knowing finding need to examine whether or not the respondent knew that the waivers were inadequate and that he could not provide competent and diligent representation to each client?
I think what the hearing panel was doing here was saying he knew there was a conflict and the waivers were insufficient. At the hearing in this case, I did argue a negligent finding because the respondent should have known that these waivers were insufficient. I did not take exception to this, but I understand the question of, can both of those things be true? I think an attorney looking at these waivers would know that they're not fully encompassing all of the conflicts in this very convoluted case.
Right.
And so he attempted to, but he was not successful in waiving that conflict because he did not go through all of those things that are required.
Right. It's just, I wouldn't want, I guess wanted to test your position that you weren't suggesting that the securing waivers alone constitutes a knowing violation.
No. If the waivers are sufficient and they have all those material risks, they outline what the conflict is and they give those reasonable alternatives as is required under KRPC 1.7 and those conflicts and those comments, then if there's a conflict that can be waived and the waivers are obtained properly, then it would not be a violation.
And in order to substantiate the knowing finding, doesn't there have to be some particularized factual finding about what the respondent's state of mind was, as opposed to an objectively reasonable lawyer? That sounds like evidence for a breach of the standard of care, negligence, etc. How do we get from that to knowing?
How do we get from that to knowing? I think the evidence, the information says that the respondent believed that those were appropriate waivers. But I think if you look at the waivers, and right, it's always hard to put yourself in the mind of somebody else to prove that specific mindset that they have. But if you look at those specific waivers, I mean, they're this tiny little bit on the bottom.
We're not
of the
arguing
page
about
thing.
whether they're sufficient or not.
Right.
It's admitted they're insufficient. I'm looking for something in the record, evidentiary, something that's of evidentiary value that elevates this beyond negligence to knowing. And it kind of sounded like what you just said was there isn't anything except the waivers themselves.
Correct, because I think the waivers are what would take this from being not just knowing that there's a conflict, but to not violating the rule. If that makes sense. So on its face, this was a clear conflict. If the representation was going to continue, then 1.7b requires an informed consent waiver in writing. And so the only other evidence we have are the waivers that were presented that are insufficient, that do not follow the rules.
You would agree, or would you agree, that there are no factual findings by the panel that the respondent knew the waivers were insufficient?
Yes, I would agree to that.
You ended your comment with the statement of lack of injury, which is an important distinction when we look at the standards between 4.33 and 0.34 of whether there is actual injury in 3.3 and no injury in 4.34. So could you address that, please, and how that impacts your recommendation, whatever that is, if you give you a chance to talk about that in as to discipline?
Yes, and Chief Justice, I'm out of time. May I please answer your question?
You may.
So I think the 4.33 and 4.34, which were cited by the hearing panel, 4.33 says causes injury or potential injury. And as you indicated, 3.4 is no injury or potential injury. So they're very similar. I think in this case, the potential for injury was very great. We're talking about a criminal case with conflicting interests potentially for B, A, and J, O. And as this court knows, when we're dealing with conflict and representation in criminal cases, there can be severe injury. There can be reversal of convictions. There can be, having to start those criminal cases from the beginning. And so that potential for that severe injury, I think, elevates this to that 4.33. I think whether it's a knowing or a negligent finding, a published censure is appropriate in this case. Looking at the standards for failing to avoid conflicts of interest as outlined by the annotations for imposing lawyer sanctions. That aligns with the aggravating and mitigating factors, the one violation of 1.7, and looking at 4.33, a published censure. I am requesting this court to impose. So I am asking the court to find and adopt the findings of facts and conclusions of law of the hearing panel and impose a published censure in this case. Are there any further questions? Thank you.
Thank you. Mr. Vogel?
My name is Jerry Bogle. I represent Stephen Wagle. I reserve time for my client to present pro se.
You certainly may.
2 minutes, please.
Okay.
Your honors, I heard that long recitation of facts. I had a hard time understanding it when I studied it, and I had a hard time following it today. And then the questions that have been asked lead me to speak initially to the facts. The facts in this case, when boiled down to the nub, are that number one, on a particular consent form or waiver, found to be insufficient, but at the time to suggest that when he prepared it, he knew he was preparing an insufficient waiver is illogical. It doesn't make sense. It's irrational. But number one, he didn't get all the case numbers on the waiver because there were multiple cases involved, as you could pick up from the recitation of fact. Number two, my time's not running.
Thank you for noticing. I think we've got you. That's okay. Thank you.
Do I start from scratch?
No, I think did you have it running? You had it, I think they had it running, they just didn't display it. So I think that's the time that's left, basically.
Thank you very much.
We won't hold you to the second on this for certain.
So number one, when they discuss the waivers, they talk about the fact that not all the case numbers are on there. You have to remember we're in the middle of COVID. The criminal dockets are jammed. The assignments are coming out left and right. They're really putting pressure on the criminal lawyers to take all these cases. And that's why we have all these cases in this instance. Number two, the other thing that didn't happen in this case that should have is that the waiver had insufficient language in it. And that the council suggests annotation number 21, and annotation 21 does say what she recited, but I suggest that not all good lawyers have read annotation 21 in relationship to the detailed necessity in order to satisfy a waiver that would protect the conflict of interest. So those two things are what happened here. No number on one of the waivers. Number two, in addition, the language of the waiver being insufficient. The subject we're talking about here is the appropriate discipline, and that's been raised by your honors. And we do agree that American Bar Association 4.33 and 4.34 are the applicable standards of discipline. And we believe that and counsel, our Justice Siegel brought up the issue and the question was answered. Is there evidence in the findings that he knew? And she concedes.
Can we stop right there? Did you take exceptions to any of those findings? You didn't, did you?
I did not.
So now you're arguing that there are exceptions?
I'm arguing that the evidence does not support the knowingly
Well, you didn't take exception to that.
I understand, but I'm only here today under the,
On the matter of what the appropriate sanction is. It's not about taking exceptions, or it's not about contesting evidence, or contesting findings that you took no exception to. The time to do that was when you you should have taken exceptions and then proceeded accordingly and asked these questions, but you didn't do that.
I understand what you're saying. We're here on the acceptable discipline.
Correct.
And I would suggest to you the cases that are close, but we don't have any informal admonition, so that I can't compare them to findings in those cases. But I can compare them to cases where there's public censure. The cases that I would like to bring to your attention. One is in Ray Stedman. And in that instance, we had multiple violations. We had 1.7A, 1.88F, 1.6, 1.16 paren D. And in that instance, and I want to emphasize the major distinction between that case, even though there are multiple citations, the major distinction is the finding that the respondent lacked candor, that he was deceptive and misleading in testimony to the tribunal. So that case, I think, does not stand for the fact of public censure. There is also a quotation that I'll read to you. It's very brief, page 1011 of that case. And the case is Kansas Supreme Court 118992, 2018. And on page 1011, the court finds that negligence is the least culpable mental state. Well, if negligence is the least culpable state, then we should have the least culpable penalty. And that's what we're arguing in this instance.
4.33 refers to negligence.
Pardon me?
4.33 refers to negligence.
Yes,
And 4.34 refers to negligence.
correct.
I think both of those sections put us in the land of talking about negligent conduct. So I think that, I think that those provisions put us in that area you're speaking of. So I think we have to focus then on some of the other things that distinguish those two provisions, which include harm and number of repetitious conduct, those types of things. Would you agree with that, or is there some other distinction that you see?
Well, there are other cases that I'll briefly make a note of. There's N. Ray Geating, which is 270 Can 139 2000. In that instance, the attorney, the respondent, was representing a client who was buying a right of redemption. And then he was also offering to represent the person whose redemption was being bought. And the distinctive issue in that case is that the respondent refused to acknowledge that he had done anything wrong. He refused to admit, he refused to take the position that he would have the ability to practice in that area without acting as he had in that case. And the Supreme Court at the end used the word caveat. They said caveat to the respondent, you better get your life in order, because we're concerned that you haven't acknowledged the violation that you made. And in that instance, he did get a public censure.
Let me ask you this. The respondent's been practicing law since 1986. He's had 3 informal admonitions, right?
Correct.
2002, 2003, also in 2003, was suspended for 1 year from the practice of law by this court. And then he got another informal admonition in 2014. So what good does another informal admonition do when you're sitting where we are, which is part of our function is the protection of the public?
Well, those informal admonitions are quite distant, number one. Number two, one of them was because he said Steve Wagle, an associate. And they said, because you said associate, you've misrepresented to the public. I find that to be a rather minor prosecution on that issue. Number two, the other informal admonition was, one of them was for, he was in a litigious divorce, and the ex-wife had made a claim against him, and that's what precipitated that admonition. The suspension arose out of a bankruptcy case where they were making charges that appeared to be commonplace in the industry. Nevertheless, they were found to be a violation, and that's what created the suspension. The fact that the timing of those and the distance and timing and the number of years that Mr. Wagle has practiced, Mr. Wagle is 70 years old. If you haven't had a complaint against you in a period of 30 or 40 or 50 years, I don't know if you're seriously practicing law. I mean, that's the nature of our work and the nature of complaints. Somebody complained that he had an extra word on his letterhead. I don't find those to be of consequence. And for that reason, we think the informal admonition would be adequate.
If we can focus on this case and the facts of this case.
Say again?
If we can focus on this case and the facts of this case, as I understand the disciplinary administrator's office, one of the things they focus on is the fact that we have two people who are involved here and the potential for harm to both ways. And that to me is one of the critical distinctions between 4.33 and 4.34. Do you have a response to that about how this immediately brings us into that language about whether the representation will adversely affect multiple people?
Well, the council acquiesced in the fact that had the waiver been properly drafted, it would not have been a violation of 1.7A. And in this instance, these people, these boyfriend, girlfriend, they both insisted that he represent both of them. He started out that way. Eventually, they did get another appointment for one of the parties, and no injury occurred. It's conceded that there was no injury. I'm now at 2 minutes. If I'm through, then I'd like my client pro se to speak.
All right.
If it please the court, Stephen Wagle responded. I'm sorry I took this case and I shouldn't have taken it. In hindsight's 2020, of course, everyone knows that. But I'm sorry because my actions reflect poorly on the bar as a whole and reflect on every lawyer, including the 6 of you, your lawyers. I will say in my defense, it was COVID, and the conflicts office at the public defender's office had shut down. They took their limit in 1 month, the first month of COVID. The public defender's office shut down, and so everything was coming out the door, and a lot of things were getting filed, and I didn't feel like I should turn cases down because of service to the bar. I really felt that way because it was so easy for a defendant to get a continuance back then. All the fellow had to do was say, let's say that everyone was prepared for a preliminary hearing. All the lawyers were prepared. Everyone was up there. The judge had time scheduled on his calendar. The lawyer showed up to the front door of the courthouse and said, I've got a cough. I don't feel good. I think it's COVID. He'd do an about face. And then they call up to the judge and no defendant. Judge had to give him a continuance. So the dockets were just stalled. Nothing was happening. I tried 2 cases during COVID. One was a murder trial. It was difficult. It's very difficult. You had to wear masks, you had to wear face shields. Hard to find juries. But I'm going to do better in the future. I will never take another conflicts case. Of course, I've always had a running conflicts list and I still keep that. But if there's even if I think it's conflict, I'm not going to do it. I did, in my defense, make both of these people sign waivers, sign written waivers, witnessed. But I do believe that my actions were negligent, and I do ask the court to follow the advice of my attorney and give me an informal admonition. But I do apologize for taking the court's time and the disciplinary administrator's time and any damage to my two clients.
Members of the court have questions for either Mr. Wagle or Mr. Bogle?
Thank you.
Okay, thank you to both of you. You reserve 3 minutes.
May it please the court. Unless there are any further questions for me, I would waive my rebuttal time.
All right, thank you. Thank you to both counsel for your arguments today. The court will take this matter under advisement, which means that today we will begin discussing the case and will assign a justice to author an opinion. That opinion will circulate among the members of the court. Once a decision is made as to that opinion, and any dissenting or concurring opinions are also written if there are any. The matter will be published. I often comment that sets us apart from other branches of government and other functions within our government, because in courts, you usually can determine exactly what the rationale and reasons were for any of the decisions that come out from either the judge or, in this case, the justices. So with that, we are now adjourned from this docket. Thank you, counsel.
All rise.